Good morning, everyone, and welcome back to our weekly webinar series. We are at episode number 176 and continuing the understanding of the IBC Amendment Bill as introduced in the Lok Sabha and passed over to the committee. Over to Anil sir.
Thank you, Ankit, and welcome to all the participants to our episode number 176. And today we are discussing part 2 of Insolvency and Bankruptcy Code Amendment Bill 2025. In the last episode, which is episode number 175, we discussed some of the provisions and also tried to explain all those reasons which has influenced this amendment. However, we got the feedback that everyone would like to go quickly through all the amendments, and maybe later on we would actually come back to all those judgments which are now kind of nullified or least impactful based on this amendment, so that we can discuss later after we finish this complete understanding of IBC amendment. So therefore, today we would not be discussing at length all those reasons which has influenced this kind of amendment. So therefore, we will straightforward go to the amendments which actually have taken place, and we will see the clause by clause deliberations, of course, we see, and some brief reasons why these amendments have actually been brought. Now, we have already discussed up to section 10 of IBC, and today we would be discussing section 11 of the IBC. The existing provisions of section 11 says that the persons not entitled to make some applications for initiating the CIRP under section 7 or under section 9 or under section 10. So it is only a consequential amendment, because simply the proposed amendment is that they also have added the chapter 4A. In case any insolvency which has concluded under chapter 4A, the fresh insolvency cannot be commenced for at least 12 months from the date of making the application. Suppose the application that is being made today, and in case we go back 12 months back, and then we have to see whether the resolution process was concluded within the 12 months or not. If it was concluded beyond 12 months, then there is no bar. But in case it was concluded within the 12 months, then there is a bar. Now, in case a resolution plan is approved, after the approval of the resolution plan, the management also changes. But again, there are some defaults other than those defaults which were there in that resolution plan, because that is an issue of implementation of the resolution plan. But once the resolution plan is implemented, and again there is a default within 12 months from the approval of the resolution plan, so the fresh insolvency cannot be started. That is, now the insolvency can be under chapter 3A, which is the CIRP, or it can be under chapter 4A, which is the creditors-led insolvency. That's only consequential amendment, because see, the bill has introduced chapter 4A for creditor-led insolvency. Now, this is again, as I said, that it is only a kind of consequential amendment. So therefore, we are not looking at the kind of various judgments which has influenced. And in fact, it is a consequential. So there are no judgments or there are no instances which has influenced this part. Now, we move on to section 12A. A very important amendment, 12A. We would be discussing some little judgments which actually have influenced this amendment. The existing section 12A was a very, very brief section, and it only said that the withdrawal of application admitted under section 7, 9, or 10, and the adjudicating authority may. the word used was may, allow the withdrawal of application admitted under section 7 or 9 or 10 on an application made by the applicant. On an application made by the applicant. Applicant means the person who made the application under section 7, 9 or 10 with the approval of 90% voting share of the committee of creditors in such manner as may be specified. However, the proposed amendment have changed this word by the applicant to the resolution professional. Now, the application under section 12A can only be submitted by the resolution professional and not by the applicant. Now, the section says they have also added subsection 2, and it says that the subject to subsection 2, the adjudicating authority may allow the withdrawal of an application admitted under section 7, 9 or 10 on an application made by the resolution professional with the approval of 90% voting share of the committee of creditors in such manner as may be specified. Now, the manner will be specified by the board. Now, subsection 2 says, notwithstanding anything contained in any, that's a non-obstante clause, any law for the time being in force, an application admitted under section 7, 9 or 10 shall not be withdrawn. Shall not be withdrawn before the constitution of the committee of creditors under subsection 1 of section 21, because section 21 constitute a committee. So unless a committee is constituted, the CIRP cannot be withdrawn. So therefore, in most of the cases, when the CIRP starts, the promoters or any other interested party will go for filing an appeal and saying that we are settling, we are withdrawing. So like there are so much of litigation. So this is now concluded that with this amendment, the application, the CIRP cannot be withdrawn. The withdrawal of the application. Now the adjudicating authority may withdraw withdrawal of application. It cannot be withdrawn before the constitution of committee. See, in most of the cases, the NCLAT will pass an order that the committee will not be constituted. And that order may even go for about 2 years. So that is the delay which is now avoided by this amendment. Very, very important amendment. Also, like one, after the first invitation for submission of the resolution plan, when the expression of interest is invited for submission of resolution plan, after that, it cannot be withdrawn. So the only period that we have for withdrawn is one, after the constitution of committee and before the expression of interest is released or issued in the newspaper. So nowadays the expression of interest is released within 60 days. Within 60 days from the commencement of CIRP. And the committee is constituted within 21 days from the date of publication. So that means that we only have about 35 days within this period. Within this period, only an application under section 12A can be submitted, and then provided that the adjudicating authority has not passed an order within such period, it shall record the reason. And now it is also important. There is a timeline which has been prescribed for adjudicating authority, that adjudicating authority shall pass an order under section 1 within a period of 30 days from the date of receipt of the application. So the timeline is also provided now for the adjudicating authority. Although there are various timelines which are provided in the code and in the regulations, but those are not being met only because the adjudicating authority is having too much of work. Provided that the adjudicating authority has not passed an order within such period, it shall record the reasons. It shall record the reasons. So in case we see the most important judgment, which actually was in the case of Glass Trust Company LLC, in the case of Byju's, where the Supreme Court in fact has said, Supreme Court set various guidelines for withdrawal under section 12A and regulations 30A must be, and it was said that it must be through a resolution professional. So NCLT conducts adjudicatory review, no bypassing via inherent powers NCLT Rule 11 or Article 142 should not be used. So whatever was decided by Honorable Supreme Court on 23rd of October 2024, in the case of Baiju's insolvency, it is being codified now. It is being codified now because in that case also, the Honorable Supreme Court has said that it should not be done, that the all these rule 11 of NCLT, Rule 11 of NCL 80, and also Article 142 should not be used. And the regulations, as it has been made by the board, should be completely adhered to. So that is what is codified, because most of the judicial authority says that the regulations are directory, regulations are not mandatory. Therefore, it has been now codified. Now, the impact of Section 12 amendment would be one, that it actually provides that the bill seeks to substitute Section 12A completely and providing a power to adjudicating authority to allow an application admitted under Section 7, 9, or 10, and that too with the approval of Committee of Creditors and 90% voting. The COC has full control after the case is initiated. They prevent misuse. Now, this particular amendment will actually prevent misuse, as there is restriction on the withdrawal, for example, after resolution plan invitation, are crucial to prevent abuse of CIRP process, ensuring that once a certain stage is reached, the process is completed efficiently. And timeline is also provided. Timeline is also provided. So this amendment, in fact, will reduce a lot of litigation. As I said, the GLAS Trust Company LLC versus Byju's has actually been impactful. This is the judgment which has influenced this amendment. And also, in the case of Brilliant Alloy Private Limited versus S. Raja Gopal, it was, of course, in 2018 judgment, where the Regulation 30A requiring withdrawal applications post-COC with specific timelines is directory, not mandatory. That was held in Brilliant Alloy Private Limited. That actually is now overridden. It is nullified, but GLAS is now already codified. Similarly, in the case of Swiss Citizen and Wallace, and we are not going the all see. So basically, the challenges which in fact was being faced would be addressed now. One, that the delay for pending appeals, exclusion of operational creditors in the decisions. Now, once the operational creditors start CIRP and the decision is being taken by the COC, where this in the COC that operational creditor is not present. And also whether the Section 30, Regulation 30A is ultra vires or not, and the disruptions to prospective applicants' investment, because see, once the applicant comes, applicant submits their earnest money deposit, and applicant also submits like kind of the resolution plan related investment, and then 12A application comes, and all the applicants, prospective applicants, they just waste their time. So that is what the impact of this amendment would be. And also, it was also being criticized that one person who actually is being paid by the corporate debtor and the others are not paid. One person who actually filed the application, he is being paid and the others are not paid, whether it is a preferential transaction or not. Secondly, that means a company, in case a CIRP is started under Section 9 by an operational creditor, and by the time the application is admitted, there are other applications already submitted under Section 7 by the banks and financial institutions. Now, that Section 12A comes and then everything is... See, in case there is a default, other defaults, other than that applicant, then why that applicant should be paid and the others are not paid? So this was the criticism. So therefore, this is absolutely 12A is now mandatory. It is not directory, because earlier it was Regulation 30A. Now it is mandatory. It's a time-bound framework. It is overruling flexible interpretations to enhance efficiency as recommended in the expert analysis. So, Ankit, I think you can add, because the 12A and especially this GLAS class, this was the good judgment.
I believe this 12A is one of the reasons why many CRP cases are still kind of stretched and they get prolonged. One of the cases that where I am the RP, the 12A proposal is under consideration with the creditors, after the liquidation application was filed, and then it since then it has been under consideration with the creditors for the past 8 months. So there is a problem with the existing 12-way scenario. Also, there is a very strong incentive for the CD to go to NCLAT, get a stay on the COC formation, and try to just settle with one creditor. And when that happens, the CRP starts again after some time. So that again is a problem. Another company where I'm an RP, the CRP started a year back and then it was settled through 12A and then it again went into insolvency after a year. So if the company lost almost an year in kind of, when going through the processes, and the liabilities might have increased in that time. And the possibility of resolution also would have reduced when the company was still trying to struggle and work outside IBC. So these are, I think, good. This is 12 is a good change, and it will allow the settlements to happen prior to NCLT applications, which is the intent of law. It shouldn't be that the settlements with the creditors start or happen after the application is already filed at NCLT. It should all happen before NCLT filing. That should be the message to companies that once the application is filed, within 14 days, CRP will start. So in case you want to settle, in case you have the capacity to arrange that money and pay the creditor, then you do that before the filing.
So moving on to the next amendment, which is in section 14, the section which actually is for moratorium, which is moratorium is a benefit given to the corporate debtor during CIRP. Because see, in this moratorium, the no litigation can be started and nobody can recover the money. So there is an amendment in this section 14. The amendment is that it is basically by way of an explanation, which says that for the removal of doubts, it is hereby clarified that the provisions of subsection 1, that means the moratorium, shall also apply where the surety means the grantor, seeks to initiate or continue any action or proceedings against the corporate debtor pursuant to a contract of guarantee. Now, this was in fact there were various judgments. In fact, let us understand what is the dispute. The dispute is in the case of State Bank of India versus V. Ramakrishnan. It was held by the Honorable Supreme Court that Section 14 moratorium applies only to CD and not to the personal guarantors or sureties. So the creditor can initiate continue proceedings against guarantors under SARFAESI Act during CIRP, as Section 14 does not mention guarantors, emphasized co-extensive liability under Section 120A of the Contract Act, but prioritize IBC creditors' recovery goals. Again, in the case of Lalit Mishra, NCLAT in fact ruled that the guarantor's right of subrogation. So this is most important. Guarantor's right of subrogation under Section 140 and 141 of the Contract Act is not absolute in IBC proceedings. IBC is not a recovery forum. Allowing subrogation post-resolution plan would encumber CD assets and benefit guarantors. Again, in the case of asset steal, the similar action was taken, similar opinion was given. So basically, because of all these amendments, now the same has all these judgments, it has been codified that now the Section 14 aligns with various Supreme Court decisions, including Lalit Kumar Jain versus Union of India, where the Supreme Court upheld the independent liability of the personal guarantor, but emphasized protection of the corporate debtor under moratorium. It also closes the subrogation loophole because there were many guarantors who in fact paid some amount to the creditors, and now that guarantor is claiming that amount from the corporate debtor and filing an application under Section 7, claiming a right of subrogation. That is also a loophole which has been closed with this amendment, and this is a comprehensive protection, ensures that all recovery actions, direct or indirect, are paused during CIRP, allowing for uninterrupted resolution efforts. Moving on to Section 16 amendment. Section 16 is the appointment and tenure of the interim resolution professional. Now, the proposed amendment says where the application for CIRP is made by a financial creditor, the resolution professional as proposed in the application under Section 7 shall be appointed as interim resolution professional if no disciplinary proceedings are pending against him. So that is one, the resolution professional as proposed in the application. As proposed in the application is something that is being focused here. So the amendment is the, like, see, I would say the Section 16 amendment would say again it says, let us understand the impact. No, impact says that there is a insertion of Section 3A. It says where an application for CIRP is made under Section 10, the adjudicating shall make a reference to the board for recommendation of an insolvency professional who may act as an interim resolution professional. So that means that for Section 10 application, there is no possibility of recommending an IRP by the applicant. Under Section 10, only the adjudicating authority will appoint an insolvency professional. Of course, the word written is that it will go to board, but practically, the NCLT will appoint it from the panel of the insolvency professionals, which is prepared by IBBI every 6 months, and that is available with the bench. So out of that panel, the IP would be appointed as interim resolution professional. Now, again, another insertion, which is insertion with subsection 4 has been inserted. The board shall within 10 days, that is, of course, recommend the name of an insolvency professional. But the basic issue is that the yes, RP can be appointed. And the one issue which was in fact decided by Honorable Supreme Court in the case of Phoenix ARC Private Limited versus Spade Financial Services, where Honorable Supreme Court on February 1, 2021, in fact, ruled that related parties, that is the promoters or entities with close ties, should not unduly influence CIRP, including through professional appointments, emphasized IBBI role in ensuring impartiality. So this was the judgment of 2021, and also in Flat Buyers Association versus Umang Realtors, NCLAT held in 2020 addresses the concerns in the real estate CIRP where the debtor-nominated RPs were perceived as biased, leading to delay and creditor distrust, suggested stronger regulatory oversight for appointments. So therefore, the Section 16 amendment now says that for Section 10 application, the debtor would not propose an IRP. And of course, 10 days a recommendation time IBBI will give, but that will be appointed through the panel, and the control will remain with the IBBI while they will actually decide about the panel. So this is an amendment primarily that the IRP should be independent. IRP should not be recommended under Section 10 applications. So therefore, the debtor-appointed professionals should be avoided. Moving on to Section 18 of the IBC, the proposed change. Anything that you would like to say, Ankit? There are some questions also probably we can take.
No, I believe I've answered that question that was there. That was not relevant to this provision per se. And this change is something that's been around since a long time. I think this was something that has been under discussion for a long time, that CDs who are filing their own insolvency should not be allowed to choose the resolution professional. And I think it's good only that it is getting implemented, because what it used to do is it used to create this scenario where the change was kind of almost there. Like wherever the CD used to propose an RP, the creditors were as a policy used to change the RP because they used to feel that the RP's loyalties lie with the company.
Moving on to section 18, it's a very important amendment where the proposed amendment is that it is again by way of an explanation for removal of doubt. It is hereby clarified that the interim resolution professional, while collating the claims, shall verify them, and if required, determine the value of such verified claims also. So earlier, there was some kind of conflict. The IBC code was saying that it is only the duty of the RP to collate the claims, whereas the regulations were saying that the RP also verify the claim. Now, the verification has now been said that it will be verified. So therefore, the verification part is now complete here. So therefore, the subsequent amendment says that the entire part of verification during liquidation process has been removed. Now, what is the change? The change is that the claims will be verified during the CIRP or even the creditors-led resolution process. Once the claims are verified, including their valuation, thereafter, during liquidation, there is no need of verification of claim again. It is only required to update. If there is any change, it is only required to update. So that is what is a very big change. During CIRP, the claims are supposed to be verified, and it has to be now communicated that this is what has been verified and this is what has been accepted and this is what the valuation that has been given. Now, receive and collate, the word has been added in such manner as may be specified. So that means how the claims will be collated and verified, that will be specified by the board, and by way of an explanation, shall verify them, and if required, determine the value of such verified claim. That is what has been added. So again, there are various judgments where in fact, it has been clarified many times that in the case of Satish Kumar Gupta, even the SR Steel, the Supreme Court highlighted that there were delays from unverified claims, urging clear professional role in claim assessment to expedite CIRP. Again, in the case of Jet Airways, the clarified IRP's duty to verify claims based on records, but noted statutory ambiguity led to disputes over unverified claims. In the case of Edelweiss versus Sachet Infrastructure, noted disputes over claim valuation, contingent claims due to unclear IRP mandates causing CIRP delays. And again, in the case of Vijay Kumar Jain versus Standard Chartered Bank, Supreme Court stressed timely claim processing to avoid CIRP disruptions, noted unclear IRP duties. So therefore, it is very clear now that Section 18 has been amended. The prescribed procedure empowers IBBI to prescribe procedure. Verification duty is on IRP. Valuation authority is also on IRP, and therefore it reduces disputes. And also when liquidation will start, there is no duplication of work. The same work which was done by the IRP or even RP, that will continue during liquidation, and only the liquidator's job will be to update in case there is any change. Moving on to section, in case there is no question, Ankit, should I move on to section 19?
I think just one thing here, that now, of course, the claim admission process and the regulations that will be built to kind of handle this prescribe the rule making power. That is, I think, that will help the process, that the RP will be one, become more accountable for the claim processing that is done doing. Number two, all the current judgments that we have where the RP is only supposed to verify, he does not have powers to adjudicate, to determine the value, all that will kind of end. And now the RP can say that, yes, this is the value that I'm determining, and this is the basis of determining that value. So maybe the regulations will be able to provide how the RP will come to that conclusion. In case there is a judgment in favor of the creditor, then the RP is required to kind of give complete credit of that amount, or that creditor has to be admitted for the complete value. In case there is an alternative legal dispute that is there, which is not giving any power to that creditor with respect to their claim, then that can be another thing. If the books of accounts kind of provide for some liability towards that creditor, then that can be part of the process. So I believe it expands the scope to kind of for IBBI to give a lot of direction as to how the RP should complete the claim process.
Right, right, you are. So moving on to the next amendment, which is the amendment in section 19, and the existing provisions of section 19 says personnel to extend cooperation to IRP. The personnel of the corporate debtor, its promoters, or any other person associated with the management of the corporate debtor shall extend all assistance and cooperation to the IRP as may be required by him in managing the affairs of the corporate debtor. Now, the change is, it's basically a marginal heading change. In fact, instead of personnel, now it says personnel. In fact, it is replaced with the persons. In fact, personals can only be considered as the KMPs or anyone who was employee of the corporate debtor. But now this has been expanded to persons. Now the expansion is that any person who is or has been a personnel of the corporate debtor or its promoter or associated with the management of the corporate debtor or engaged in a contract for service with the corporate debtor shall extend all assistance and cooperation to the IRP. So how it has been expanded? One, instead of personal, it is any person. Whether he was an ex-employee or he is a current employee, that is also covered. Whether he was associated with the management of the corporate debtor in any manner, or he was even engaged for a contract of service. So everyone, even the consultants, all those consultants who have ever been engaged by the corporate debtor are covered now. They are supposed to. Now the section 19 subsection 2 application can be filed against any person who even ex-employees, even any person who was associated with the management, even any person who was engaged for any kind of service, maybe a lawyer, maybe a chartered accountant, maybe a consultant. Everyone can be dragged under section 19 subsection 2 to before adjudicating authority in case he is not providing the information which is being sought by IRP. Now the terminology clauses like any personal, so it is like the section subsection 3 says that the adjudicating authority shall direct such personals. That means direct such persons, now such persons. So the new explanation has been added. For the purpose of this section, it is hereby clarified that the reference to the IRP shall also include references to the RP. Again, to nullify some of the judgments, because in this particular section 19 subsection 2, it was only the word mentioned was IRP. So it was also questioned whether RP can file application under section 19 subsection 2 or not. So this is again a good judgment so that the section 19 subsection 2 can be in fact used, can be used. So all this amendment that we have said, it is again based on various in fact disputes, and broadening the scope is one. I think the terminology alignment, clarity on the RP inclusion and enhancement. So then again we move on to section 21. So one, in case we have to conclude section 19. The amendment is only to broader this scope, and also terminology is now aligned with the section, and clarity is on the powers of the RP, and also the enhancement of the enforcement, which actually the NCLT can pass an order directing any person. Now, amendment to section 21, which is for constitution of committee of creditors. Now, the present section only says that it is again kind of clarificatory. It says that it is only regarding voting share adjustment. There is presently no provision for the COC's role once liquidation has commenced. Once liquidation starts under Chapter 3, the COC typically ceases to exist and the liquidator functions independently with the limited creditors' oversight via stakeholders consultation committee. Now, the section which has been inserted is where liquidation is initiated under Chapter 3, the COC constituted under Section 21 shall also supervise the conduct of the liquidation process by the liquidator. Presently, the liquidator ceases to exist, however, based on some regulations changed in the last 1 year. The COC will continue at least till the stakeholders consultation committee is constituted. That is the present regulation. However, now the amendment has been done in the code and that is much larger. Now the COC will continue during the liquidation process. Complete liquidation process, the COC will continue. And also the board will decide who other class of creditors will participate into the liquidation process, but without voting. Because we have seen in the present, as per the present regulations, we have seen that there are every claimant is a member, including the statutory authorities, and they are not taking any interest, although they have a voting power, but they are not taking any interest in the liquidation process. So therefore, the decisions are delayed. Now, in case the COC continues, then the COC will continue and the COC will also continue with their understanding about this company. Now, the provisions of Section 21 and 2 and up to 24 shall apply during liquidation also to the extent applicable. And that means all the provisions regarding convening meetings, giving notices, conducting the meeting, everything will apply during liquidation also. All the timelines for circulation of the minutes or circulation of the agenda will apply during liquidation also. And once this bill is passed and becomes an act, I believe all those regulations where the stakeholders consultation committee is constituted and the powers of SEC, those would be deleted, because see, in this case, all these powers will come to the committee of creditors. Then the IBBI will actually specify any other class of creditors who would also participate in the COC during liquidation process, but without any voting powers. So this amendment, in case it is passed, this will be applicable only to the liquidations initiated after the commencement of the Amendment Act 2025, and also the ongoing liquidations where Section 54 application has not yet been filed, COC will continue until the liquidation. So once this bill is passed, then all the existing SCCs will be replaced by the committee of creditors unless the dissolution application has been filed. So I think we have already explained, and then there is no way that we should again read the text, amended text. And again, I think there are a lot of judgment that we have. See, the impact of this amendment would be that the new governance layer in liquidation, one is the COC, plus there will be some class of creditors that will be allowed to participate without voting. Then the COC has an extended life as their role is important. The regulatory flexibility, the IBBI will make further rules and regulations for adding other class of creditors, and then the procedures will be uniform. May it be COC during CIRP or may it be COC during the liquidation process. Yes, Ankit.
Yes, so looks good. We can continue.
So Section 22, amendment to Section 22, which is regarding the appointment of a resolution professional, I think this is the most welcome amendment that we can see. See, we have seen in the past that the most of the benches or some of the benches are in fact appointing liquidators or even resolution professionals other than what is recommended by the committee of creditors, and especially in the case of liquidations. Now, the relevant part that we would only be reading, the relevant part of section 22, subsection 2 says the committee of creditors may in the first meeting by majority of vote of not less than 66% of the voting share of the financial creditor either resolve to appoint either resolve to appoint the IRP as a resolution professional or to replace the IRP by another resolution professional. And then where the committee resolve to change, it will file an application to adjudicating authority, and otherwise it will so now the proposed amendment says when the COC resolves to continue the IRP as RP, the person is deemed appointed as RP from the date of COC resolution. So therefore, on the same day, the IRP will be deemed as RP. So therefore, the communication which is required to be sent to adjudicating authority, that is now communication would be required to be sent to the corporate debtor, IRP, and the board instead of adjudicating authority. So the adjudicating authority's role and their load is little bit of reduced since the COC has already appointed him as the RP. So there is no communication which is required to go to adjudicating authority, but it will go to IRP or it will go to the corporate debtor, and it will go to the adjudicating authority. So the no NCLT order is required now, and even the administrative realignment, now it is only supposed to be notified to IBBI instead of adjudicating authority, and also the gap is reduced. Smoother handover of powers, meeting timelines, that has been proposed. But in case of change, definitely it will go to adjudicating authority for change. Now, the duties of resolution professional, which is given in section 25, that is where some amendments have taken place. And the duties are in fact to protect the assets. And let us understand the change. The duties, basically, there is only one change here, that the RP to file an application before adjudicating authority in respect of an avoidance transaction or fraudulent or wrongful trading, if any. Now, this word, in fact, this is again a consequential amendment where there is a clear separation from avoidance transactions and fraudulent or wrongful trading transactions. The Piramal judgment, in fact, influenced this. In the Piramal judgment, the Supreme Court has very clearly said that it is a totally different kind of adjudication, different kind of documentation, different kind of proceedings are required for avoidance transactions, and it entirely different as far as the fraudulent or wrongful trading transactions are considered. So therefore, the fraudulent and wrongful transactions under section 67 and section 67A, which is applicable only in the case of prepackaged, that expressly is the duty of the RP. It is the duty of the RP, and the amended text is only, along with the avoidance transaction, the word has been added or fraudulent or wrongful transactions. So the judicial influence in this case is from Piramal Capital and Housing Finance Limited versus 63 Moons Technologies Limited, where the Supreme Court made a very clear distinction between avoidance application under Chapter 3 and application for fraudulent and wrongful trading under Section 66. The court, in fact, emphasized that the adjudicating authority has separate powers for these types of applications, and non-mentioning or wrong mentioning of the provisions of law in the application would not take away NCLT's jurisdiction. So therefore, the amendment to this section 25 only results into expanded scope of the duties of the RP, that the RP will file separate applications for avoidance transactions and separate applications for fraudulent and wrongful trading transactions. Whatever was decided by Piramal, that has been codified, it is the best practice that actually it should be brought to the code rather than working based on the Supreme Court judgment. So it also enhances the accountability of the IRP and the RP and improves the enforcement, because the adjudicating authority will also take it differently as the provisions are saying. Now, amendment to section 26 also says that filing of the avoidance transaction under chapter 3 shall not affect the proceedings of the CIRP, and again it will continue. Section 26, the proposed amendment says that the expanded scope now covers the avoidance transactions, fraudulent and wrongful trading transactions, and applications under section 47, which is specifically covered as section 47 is the transactions. Because see, now in case we go forward, we can see that the application for avoidance transaction, for undervalued transactions and extortionate credit transactions, and even section 49 with where undervalued transaction with fraudulent intent, all these applications can also be filed by the creditors. All these applications are also can be filed by the creditors. In case the RP files, okay. In case the RP doesn't file, then it can be filed by the creditors. So therefore, it is this section 26 only say that all the CIRP will continue, and it does not the CIRP or liquidation, it does not terminate these proceedings. It does not terminate these proceedings even if the company goes into liquidation, but these proceedings will continue, and it will continue post resolution and even post liquidation. It will continue even post resolution and even post liquidation. That is what is the amendment. Because see, there are a couple of decisions, like how the RP can wear a hat of RP when their office is, he's already vacated his office. However, there are also a kind of controversial judgments, like the company has been dissolved, how the transactions proceedings can continue. So the clarification is that even if the company is liquidation, so it will continue. The amended text that we can see in section 26 is the filing of an application in respect of avoidance transaction or fraudulent or wrongful trading under section 47 shall not affect the proceedings of corporate insolvency resolution process or liquidation process, as the case may be. And the explanation that is given for removal of doubts, it is clarified that the completion of CIRP or the liquidation process shall not affect continuation of the proceedings in respect of the avoidance transactions or fraudulent or wrongful or under section 47, as the case may be. So that is where the impact of this amendment is, again, broader coverage, no disruption to these proceedings, post-process survival, and again, NCLAT judgments or Supreme Court judgments are brought to the court. That's what it is. So, Ankit, anything that you would like to add or any question that we need to attend?
So one question that we can take up, that will after amendment in section 21, no new process of invitation for filing claim and constitution of SCC will be followed.
Yes, once this bill is passed, then in case company goes into liquidation, so whatever work has been done by IRP or the RP for verification of the claim, that will be adopted by the liquidator. However, the liquidator will only update the claims, and he will maintain an updated list of claims in case there is any change.
And the SCC will still continue, or the COC as it is will continue?
No, the COC will continue, and
SCC concept will...
the SCC concept will be totally removed.
Because what I think they've done is that they have increased the stakeholders within the COC to make the COCs look more like the SCC in the current form, where the SCC is represented, has representatives of various class of creditors. So I believe that is will be.
In fact, the IBBI has taken the power that during liquidation process, they can even add some of the stakeholders, some of the creditors in the process, but without voting power. Without the voting power, whatever has been decided in the COC, that will continue. However, participation in the liquidation or in the meetings by other class of creditors, that will be decided by IBBI from time to time.
And I believe that these changes can only be prospective. It's very difficult to make these changes retrospective for all the existing cases.
No, they have said that once this bill is passed, all the existing all the existing liquidation cases will also adhere to this provision unless the dissolution application is already filed. Very clearly, the bill mentions that.
We can move forward.
Now, we actually now would like to see the other one section after 28, and a new section has been added, which is section 28, capital A, transfer of assets of the grantor during CIRP. Again, a kind of various judgments where there are inseparable assets belongs to either another company of the promoters or any individual from the promoters group. The assets are inseparable. For example, the land belongs to promoter or land belongs to another company, and the building is constructed and the factory is continuing in the name of the corporate debtor. Now, in this CIRP or in the liquidation process, it is difficult to sell the land or building separately because these are inseparable. And also, the resolution plans cannot be invited if somebody doesn't have the land where the factory is located or situated. Now, therefore, there were various judgments that we have in fact seen where the NCLAT has allowed to sell during liquidation process all those assets which are mortgaged to creditors but are not owned by the corporate debtor to be part of the liquidation process. However, that was that the proceeds, actually that part will be sold in different, maybe SARFAESI or RDB Act. But now the law has actually been made very clear, which will facilitate sale of all those assets which are part of the business, part of the assets, and not separable. So therefore, however, there are some conditions. Now the prisons, it says that there is no corresponding section in present IBC for transferring a personal or corporate grantor's assets already in the possession of the creditors under any law, because in case the creditor has taken the possession under SARFAESI or any under RDB or under even section 29 of the State Financial Act, in case they have taken the possession of the asset, they are not able to sell it because of the moratorium. Now, the such assets and enforcement are outside the corporate debtors CIRP unless part of the separate insolvency or bankruptcy of the individual or the grantor. Now, this amendment, what this amendment says, there is a basic transfer mechanism which has been defined in this amendment, where a creditor has possession of an asset of a personal grantor or a corporate grantor of the CD via enforcement under any other law, as I said, SARFAESI, RDB, or even Section 29 of State Financials Act. It may permit transfer of that asset as part of the corporate debtors resolution plan with prior COC approval. So that asset can also become part of the CIRP process with the approval of the committee of creditors. Now, the corporate grantor, in case it is a case of corporate grantor, then and that corporate grantor is also under insolvency. So therefore, that corporate grantor's committee of creditors will decide with 66% voting that this asset can also become part of the CIRP of the corporate debtor. However, the amount that actually will be received by the corporate grantor, that will become part of the CIRP or the liquidation estate of the corporate grantor. So the two decisions has to be taken. One, in case the asset is merged into the corporate debtors resolution process, how the value would be decided. And once that value is decided, the 66% voting is required for the insolvency of the grantor, corporate grantor. After the realization of the resolution plan, that part will actually come to the CIRP or the liquidation process of the corporate grantor. However, in case that asset is covered in the personal insolvency of the of the grantor, then in that case, 75% of that creditors of that person will approve, yes, this asset can be taken as part of the CIRP of the company. 75% creditors will decide. They will also decide value. They will also decide how the value will be determined. They will agree on the value. And then once the CIRP is concluded of the year, then this particular amount which has been agreed or any basis on which it has been agreed, that will go to the resolution process of the personal grantor or in the bankruptcy process of the personal grantor. So this is where the assets which are presently not being sold, and there are a lot of litigations going on, those assets can be sold in collaboration with the COC of the corporate grantor, with the creditors of the personal grantor, and in case these two are not, in insolvency, then the committee of creditors of the corporate debtor can itself decide that this particular asset, which was mortgaged to one or two creditors, how that will form part of the CIRP, how the value will be shared. That can be decided, and then the resolution can be achieved. I believe it is clarified, Ankit, or you would like to explain it in a different manner?
No, this looks good. This looks good.
So these are again, like I said, this action, section 28, capital A. In fact, it is integrating the personal grantor's assets into the CIRP or the liquidation process. Again, it is integrating the corporate grantor's assets into the CIRP or the liquidation of the corporate debtor. The creditor's consent is required so that there is no gap in the value, which actually they can realize in other manner. So they can realize the same value in this manner. So there is basically it's a legislation. This little bit of innovation has been used so that the disputes are reduced and cases are resolved and value is maximized. Moving on to section 30. Section 30, which is regarding the RP's duty to examine the resolution plan received by him. Presently, the RP has a duty regarding the amount which actually should be allocated to the operational creditors, even if it is a secured operational creditor or unsecured operational creditors. Then the RP also has a duty to see whether the amount is properly being allocated to the dissenting creditors, even they are secured or unsecured. And also it provides the implementation and so the supervision of the resolution plan. However, in the code, presently there is no provision regarding the monitoring committee or monitoring agency for implementation of the resolution plan. However, that was part of the practice. So whatever was the practice is now being brought to the code. That has been brought to the code. Now the amendment says, first of all, the dissenting creditor was removed and it was actually moved to another different paragraph so that the clarification is achieved. Now, since there is a definition of the secured creditor and how the liquidation value would be calculated, that is also clarified in section 53. So this dispute, how much would be payable to dissenting creditor, is also now is on rest, because there is an amendment in section 53, because Amit Metallic's case was saying differently, but now this amendment will say differently. Whatever is paid, what it says now, the dissenting creditor will receive lower of amount receivable in the liquidation under section 53 or amount they would have received if the plan distribution was made in section 53 priority order, whatever is least. So that means there is a disincentive to the dissenting creditors. In case the resolution plan allocation gives him 100, however, in case the company goes into liquidation and he will get only 75, so in case he dissents, then he only will get 75 and not 100. Because presently there is a dispute. Presently there is a dispute that in case the resolution plans offer more amount, then he is entitled to more amount. So therefore, this clarification again becomes a disincentive for a dissenting creditor. Also, for the implementation, there is a clear-cut provision now that the implementation and supervision for constitution of a committee, that also has been now provided. And also, whatever was mentioned in the regulations, that such distribution must be fair and equitable. Now, the distribution to dissenting creditors should be fair and equitable. Also, the explanation 2 says amendment does not apply to CIRPs where before the commencement of Amendment Act, certain milestones were already achieved. So that actually is to remove any practical difficulties. So the even in the case of SR Steel, Rainbow Paper, JP Vidarbha, so there were in fact various judgments which in fact have influenced this amendment, and now the structure is clearer. What structure? How the dissenting creditors will get their share, and also it actually moved into a stand-alone clause. Then fairer outcome means ensured dissenting creditors get at least liquidation value or priority-based plan value, whichever is lower. Then the flexibility and oversight. The new clause formally recognizes the post-approval committee, which is the supervision and monitoring committee. Transitional safeguards are also built in, and in fact, the fair and equitable principle is brought to the code and from the regulations. Should we move to section 31, or we actually can say that it will be dealt with, or I think we can actually see that section 31 is completed, because then the most of the resolution process will be completed, and then we'll start the liquidation from the next part.
Sure, let's do that.
So in this section 31, which is basically the powers of the adjudicating authority for approval of resolution plan. So the one power which has been given to the adjudicating authority, that the adjudicating authority can approve the resolution plan if the committee of creditors suggests that, please approve our resolution plan, we can wait for distribution. So if the COC says with 66% voting power that you please approve the resolution plan and you can actually decide about our claim or our distribution little later, however, not later than 30 days. Not later than 30 days. And also, the adjudicating authority has actually been given one responsibility, that in case you find any defect in the resolution plan, you must give a notice to the COC so that they can correct that, defect before the resolution plan is rejected. Also, the timeline of 30 days is mentioned in the code now, that the resolution plan will be approved in 30 days. And in case the adjudicating authority is not able to do that, the adjudicating authority will have to record the reasons of not able to doing such. Statutory protection for the licenses and the grants, like once the resolution plan is approved, the licenses, permits, registration, clearances, all tied up with the plan, cannot be suspended or terminated for the remaining period if the current obligations are complied with. So therefore, secondly, the clean slate provision, the clean slate principle that has been brought to the code. Presently, it was only out of various judicial pronouncements. Now it is very clear that unless otherwise provided in the plan, all claims against the corporate debtor or against the assets prior to the approval date are extinguished. Also, it says very clearly that after the resolution plan is approved, no proceedings for such claims can be continued or instituted for such claims. Now, we can see in various our cases, especially in home buyers cases, the resolution plan is approved for 1 year. Even today, there are 12, 13, 15 cases are being filed almost from various home buyers who are saying that we could not file our claim on time, so we are losing. So all these proceedings, all these applications are being entertained by the adjudicating authority. Who is going to attend to this? The successful resolution applicant. But then all these applications are being filed where the erstwhile RP is being made as a party. What the erstwhile RP can do, because the bench is again asking the erstwhile RP why this claim should not be accepted, why this should not be rejected. Because so after 1 year of vacating the RP's office, resolution plan is approved, it has gone to the SRA. RP is now actually getting involved in multiple cases, so that at least I will have to go to the bench, say that I am not the RP now, but then the bench says that provide the information to us. Provide the information to us. That's what bench says. So the impact of this section 31 would be the procedural flexibility, that yes, in case there are disputes, the resolution plan can be approved and the allocation can be kept pending. Now there is a process of a rejection. Before rejection, the COC will get a notice. 30 days timeline is proposed, and regulatory certainty like the licenses, permits, everything will be retained, will not be terminated or cancelled. And then strong clean slate protection. Strong clean slate protection, and all those indemnity rights which extinguished to block indirect recovery, the right of subrogation, that is also clear. I think this is what we have. Now we will start in the next part is the liquidation processes. After the liquidation, then we will also handle all the avoidance transactions, fraudulent transactions, that what we will actually achieve and we will do in the part 3. So we tried to cover as much as possible. We also tried that not to deliberate much on the various judgments influencing the uh, proposed amendments. So Ankit, this is all that we have. In case there are some questions that we can take on, then.
No, I think I have answered many of the questions. I can ask the participants that in case they would want to raise any question, they can raise their hand in case they want to ask a question that is relevant to whatever amendment we discussed today. If they can limit their questions
In
to
fact, I have come here at Chandigarh. There is a event by State Bank of India. They have actually called the DRT judges, and they have called the registrars, and this is an event on SURFACE, and I have a 2-hour session. I have to give just a lecture there on SURFACE law, and they have, in fact, there are about 200 State Bank employees at their Chandigarh State Bank of India Learning Academy, where they have invited senior officials from the DRT also. So I have to just rush to that. I'm already there in their guest house room.
So I think we can then, should we take a few questions or should we take them later?
No, we can spend 5 minutes still.
So I am asking Lalit ji to speak. Lalit ji can unmute yourself. We can't hear you still, although you are unmuted. Then I can ask Alok ji.
Yeah, thank you, Ankit ji. Can you hear me?
We can hear you.
Yes.
Good morning, Anil ji, Ankit ji. So my question is regarding the last provision you just explained, wherein the plan approval and distribution are segregated. So my question is, in the plan, when the COC approves the plan, some members would approve the plan for the whole value as well as the distribution. So when this is provided that the distribution can be changed by the NCLT, so where does the commercial wisdom of COC go then? Then it implies that this NCLT can interfere with the commercial wisdom. Does it mean so?
So there are two things. One is the commercial wisdom of the committee of creditors, and the second is the compliance to the law. So the law says that the secured creditors, dissenting creditors should get this much. That is what is provided in section 31 and also regulation 38. Once this section 31 amended, section 31 be passed, then also the regulation will be changed. Now, there are a lot of disputes regarding, somebody will say, like, I'm not talking about those 66% who are, I'm only talking about those who have not voted for the resolution plan, or even after they have voted, they are not satisfied with the allocation which is being made in the resolution plan.
Resolution plan will talk about distribution, but what we are trying to say is that the distribution is segregated, and in case there is any non-compliance with the amount payable to dissenting creditors, or if there is any difficulty with respect to or disputes with respect to the creditor claims, because there is a possibility that the creditor claim are pending for adjudication with the NCLT while the plan has been passed. So in those cases, the change will happen. Otherwise, there is no change. So therefore, the it's like if the distribution is affected, it will only be affected due to due to this problem, due to this rearrangement because of compliance with law. This is the idea.
Sir, am I audible?
But I still think there will be a confusion when it actually comes to implementation part. So that's my view. Thank you.
Sir,
Anil
am
ji,
I audible?
Anil ji, you're audible now, yes.
Yes, sir. Under section 19, regarding the persons has been included, but in Indian Evidence Act, section 129, and now it is 134 of BSA, the advocates of the privileges, are they bound to give the information?
Advocates, see, if we read this expanded scope again, it says any person who is or has been personnel of the corporate debtor, which was anyways included in the previous definition, or the promoter in the previous definition, because the headings and all the initial references talked about personnel. Few promoters used to come and say that this section is only applicable to employees, and we were only promoters, we were never employees. Then it says, or associated with the management of the corporate debtor, or engaged in a contact, or engaged in a contact for service with the corporate debtor, contract for service with the corporate debtor. So in these cases, in case, let's say there is an advocate who has, there is record that the advocate used to represent the corporate debtor before some forum. Let's say an arbitration case. Now, the RP approaches that advocate and says that please share the documents that you have for this matter that was filed before this court. Then I believe that that will be part of this, ambit of this section now, because that personnel has, or that person, that advocate has some information which belongs to the corporate debtor and which will allow value maximization for the RP in case he gets that information.
Okay.
This is my view. This is my view.
Oh.
But then I think logically this should also make sense that the RP is simply asking for that information that pertains to the corporate debtor. That is a limitation.
Okay. Thank you.
So I think in interest of time, it's already 12:15. So I think Jyoti ji is not able to unmute herself. So we can take the remaining questions offline. I'll be happy to take care of any questions that come to me. So we will end this now. Thank you, everyone. Thank you so much. And we will take this forward on the next Saturday. Thank you, everyone.